Welcome to the next video in the East Carolina Law Group series called Court Structures of North Carolina and Understanding the Court Basic Civil Procedure. My name is Attorney Tim Koller. I'm the Principal Attorney at Law here at the East Carolina Law Group. We're located in Barco, North Carolina, in beautiful Caratoke County and just north of the beautiful Outer Banks, just south of Chesapeake, Virginia, about 20 minutes drive, and about 20 minutes drive from Elizabeth City, North Carolina. We're in the 1st Judicial District. And this is going to lead us into our topic on the basic setup of the court system and structuring in North Carolina. Now, different from many other states, North Carolina is set up in a series of judicial districts. And what districts are is various counties. It's a collaboration of counties. Now, most folks will say, well, the nearest courthouse to my house is in Gates County or in Pasquotank County in Elizabeth City. And generally speaking, you're within a district. Those county courthouses all fall into a judicial district, and there's a circuit of judges within that district that sit in those courthouses. So that's the first thing to understand. We talked about judicial districts before. So we are in the 1st Judicial District, and in the 1st Judicial District, it encompasses Gates County, Camden County, Caratoke County, Dare County, Pasquotank County, Perquimans County, and Chowan County. We're actually quite a large district, and we have several sitting judges in this district. We have both small claims, district court, and superior court in our judicial district. And so we're going to talk about what each one of those things are and what they mean to you. There are other outlying districts. There's District 6, which is west of us, which encompasses Northampton, Bertie, and Hertford County. And then there's south of us, which encompasses Hyde, Terrell, Washington, Martin counties. So that's District 2. And there's different various districts all throughout the state. So one of the things that's important when you're looking for an attorney is try to find somebody that's either in your judicial district or close to your judicial district, because they're going to have to travel. Now, each judicial district has different local rules, and it's important to have an attorney that understands those local rules. For example, in District 2 under local rules, there's a rule that states that if either party is sanctioned for discovery misconduct in an equitable distribution case, the court will automatically revert the case to an unequal distribution in favor of the non-violating party. And this is a pretty important rule for anybody who's going to undergo an equitable distribution case in District 2. You want to make sure your attorney knows that. Furthermore, in District 6, there's some kind of different scheduling rules for how to get a case put on the calendar. So understanding how that process works is very important. All of these things are very important. Not only that, court priorities and that sort of thing. So if you have a case in Superior Court and another case going on in District Court, what case takes priority? Where do you go? Who gets a continuance? Those things are important. Understand those things. Having a working relationship with attorneys in other districts is also very important, and knowing the judges. There's an old adage that says that a good attorney knows the law, but a great attorney knows the judge. And some of that is in some ways true. You want to know the judge because you want to know the temperament of the judge. You also want to know how they like to do business, and you want to know how this thing is going to kind of fall out. And so you can best advise your client strategically on how things should work. So for example, there are some judges that prefer to have an open court hearing, knockdown, drag out kind of thing, all on the record, where some judges like to try to hash things out ahead of time in chambers and try to streamline the issues. So understanding how particular judges like to do certain things is also very important. The basic court structure in North Carolina within the districts falls like this. At the very lowest level, there's the Clerk of Courts. Now, the Clerk of Court in North Carolina, unlike many states, is an elected position. He's actually a judicial officer. The first level of the court structure in North Carolina is the Clerk of Court. The Clerk of Court is an elected official, and so they actually do preside over certain judicial proceedings, such as guardianship appointments, probate, administration of estates. They also preside over other things, such as partition hearings and other such matters. They can also enter judicial orders, such as defaults and default judgments. So it's important to understand that if you're ever dealing with an elected clerk in a particular county, that elected clerk is actually a judicial officer similar to a judge, and they have authority. So make sure that you show them the proper respect due to their office. The next level is the magistrate. A magistrate is a quasi-judicial figure because a magistrate is not an elected official. A magistrate is a hired official, but they're quasi-judicial because the chief district judge in any particular district can delegate certain roles, powers, and authorities to them, such as issuing warrants, issuing orders for non-secure custody to go place children in foster care in certain circumstances. They can issue ex parte domestic violence orders, ex parte civil no contact orders, and they can also hear small claims cases. Now, it's important to understand that a small claims court, particularly in terms of civil procedure, falls inside the structure of the district court, and anything done by the magistrate is subject to review by the district court. So, if you elect to go through small claims proceedings, it's a less formal proceeding than a district court hearing. However, there is a right of an appeal to the district court. Generally speaking, small claims court's jurisdiction, what they can hear, is concurrent with district court, which means if you elect small claims, you could also elect district court. You may have a claim that falls within the statutory guidelines of $10,000 that can go to small claims court. Now, by statute, small claims can hear cases up to $10,000. But your particular district has the authority to either eliminate small claims court or to limit the amount that they can hear. And in the first district, it's still currently set at $5,000. However, whenever I have a client that comes in that wants to talk about taking a case to small claims court, I generally try to dissuade them from doing so. The reason is because most of the time, anytime you get a case that goes into small claims court, you're almost always going to end up on appeal to district court. So you're going to end up going from kiddie court, which is not really a good term for it, but it's kind of what I call it. You go from kiddie court to big boy court. You're going to end up there anyway. So you either spend the money to do it right the first time, or you spend the money to show your hand and then go back there, and then they already know what you're going to bring. Go to the correct court the first time. However, if you can't afford an attorney and you are just absolutely dead set on trying the case yourself and doing it pro se, small claims court is a fine option. But just bear in mind that you may end up getting appealed into district court, and at that point, you will need to hire an attorney because you'll have to file pleadings. If you don't know what pleadings are, it's very important. But you'll have to file pleadings, motions, pretrial, and all that sort of thing. So make sure, if you're going to use the small claims option, that it is absolutely the perfect option for you. Many cases, it's not. District court is a court of original jurisdiction for any matter up to $25,000. District court also hears cases such as domestic violence protective orders, family cases such as divorce, custody, equitable distribution, alimony. And unlike some of our sister states or our border states such as Virginia, our district court is actually a court of record where that has exclusive jurisdiction, which means it's subject to appeal. So if you take a case into the District Court of North Carolina and it's a case of exclusive jurisdiction, such as a custody case, that case is absolutely subject to appeal at the Intermediate Court of Appeals. We'll get to that in just a moment. Your next level of court for any civil case above $25,000 is going to be in Superior Court. And this is definitely big boy court. Superior Court is the senior court at the trial level. These are courts where you're generally going to see most of your jury trials, and this is where most of your larger judgments will be rendered from. Superior Court has original jurisdiction over certain matters that District Court absolutely cannot hear, such as foreclosures, and such as any case where the amount in controversy exceeds $25,000 exclusive of interest and cost. They also hear criminal cases such as capital cases, and they're the first court of appeal in most of your criminal district court cases. At the next level are your appellate courts. Your appellate courts, you have an intermediate court of appeals, and then you have a last resort court of appeals, or a court of last appeal, which is your Supreme Court. That's the North Carolina Supreme Court. You cannot automatically appeal into the North Carolina Supreme Court in a civil case. It has to go to the Court of Appeals first. Now, that process is very, very lengthy, and only certain attorneys actually do appellate work. I do appellate work. And generally speaking, if you have a case that needs to be appealed, then you're going to be looking at spending quite a bit of money. So make sure that you have a good appellate review conducted, and you make sure that you do a good consultation with an appellate attorney before you decide to undertake that endeavor. So that's the basic structure of how the courts work in North Carolina. Now, as it relates to civil cases, such as landlord-tenant, personal injury, negligence, divorce, alimony, equitable distribution, child custody, DSS, any of those sorts of things, the way these proceedings are initiated is either a petition or a pleading, a complaint being filed, a summons being issued, and then the summons being served. And in North Carolina, there's 3 ways of serving process. Process is where you are actually given a copy of the complaint or the pleading and the summons, and that has to either be done by a law enforcement officer, or B, a designated person duly appointed as a law enforcement officer. It could be a private process server, or it can be done by certified mail with return receipt. Sometimes I will have people that will come in and say, well, I got this, but I know it's not good because they sent it by certified mail and they have to have it sent by sheriff. And this is absolutely not true. North Carolina is one of the very few states that will actually allow service by certified mailing or registered mail, depending on if it's going out of the country. That's called primary service. Now, in the 1st Judicial District, one of our local rules requires that primary service be first attempted by either law enforcement, sheriff's department, or by certified mail before you can undertake primary service with a private server. Process is being served both complaint and summons. If you receive service of a complaint or just a summons, you have invalid process. You need to hire an attorney immediately. Don't do anything. Hire an attorney to file an objection. If you file anything with the court, you'll waive that as an objection. Then, the last way of getting service, if certified mailing or sheriff or process server fails, or you simply cannot locate the other party, is you can serve by publication. And this is an expensive process. It's a time-consuming process, but it is there for a reason, where you have a situation where you can't locate the other party particularly, or they're just not responding. Service of process by publication is an option for you. You definitely need to speak to an attorney. This is not something that you can do on your own. There are affidavits and other pleadings and papers that have to be filed in order for that to meet the constitutional guidelines for service of process. So make sure that you have an attorney if you absolutely don't know where the other party is. So that's the basic structure of things. Now, initiating a civil action is definitely not something that you're going to want to do on your own, and it's certainly not something that you're going to want to do without counsel, particularly if it's for any type of a serious case. Many times we'll see folks come in pro se, and if you watched our preceding videos, you know what pro se means. Will come in pro se, particularly on absolute divorces. They'll try to file for their own divorce and do it themselves. And then generally what happens is they end up in a lot of problems because they don't know how to serve process, or the other party hires an attorney and they file counterclaims, and then you're in a whole mess of hurt. So even though you can go to the clerk's office in many counties in North Carolina and you can obtain a pro se package for filing your own divorce, it's ill-advised. Please don't do it. Hire an attorney, get it done right the first time, and make sure you know your rights. That's the most important thing. And understand what court you're going to be going into. My biggest piece of advice for everybody in all of these videos is hire an attorney. None of these are designed to supplement the proper advice and counsel of a licensed attorney who is looking at your documents and knows your issues and facts. Please understand that you should always hire an attorney, whether it's us or any other law firm. Make sure that they're the right attorney for you in the right jurisdiction and have the right expertise to handle your type of case. Thank you for tuning into the East Carolina Law Group, where your family is our priority. You can find us on the web at www.eastcarolinalaw.com. You can find us on our Facebook page at the East Carolina Law Group. You can also call us at 252-453-2273. And if you want to find more videos and keep updated on when we put some more of these kind of things up for some more self-help kind of information, you can do so by subscribing to our YouTube channel by clicking on the link right about here. It's there. Down. Yes, right there. Subscribe by clicking our link. Thank you for tuning in. I hope you found this informative, and have a great day.